Thank you. Can you hear me? We're going to call the meeting to order. Judiciary A, brief announcement. We are waiting on printing for a couple of the subcommittees. So, I'm told it will be 20 minutes thereabouts. So we're going to proceed. We may have to recess subject to call while they get that here, because I do not want to proceed without the committee members having that. So we will, so with that, we are gonna take these up by subcommittees, and I'm gonna first go to criminal law and procedure, Senator England. And so that's on your second page of the agenda.
Thank you, Chairman Wiggins. I appreciate you calling on me first and letting me get these out of the way. I think they're pretty simple bills. First, we have House Bill number 1215, which is the bill that addresses child support for incarcerated individuals. We have a strike all, which is not before you, but just to tell you what we did a strike all and put the Senate language back in there. I do have an amendment to the strike all to put a reverse repealer in at the proper time, and I'm happy to answer any questions on it. But again, we're just putting the Senate language into the bill, and my amendment will be to add a reverse repealer.
Okay, we're on the amendment. The amendment is to add a reverse repealer.
That's correct.
That's your amendment. Okay, any questions on the amendment? All in favor, say aye.
Aye.
All opposed? Okay, thank you. Now we're back on the bill or on the strike call as amended. Any questions?
My motion, if there are no questions, is title sufficient, do pass, strike all as amended.
Very good.
I just wanted to get all
Very
that.
good. That was good.
Make sure we get the.
You heard the motion. All in favor, say aye. All opposed?
All right, thank you, committee. The next and final criminal procedure bill that's on the agenda today is House Bill 1217. This comes over as a request from the Administrative Office of Courts, just kind of codifying language that deals with court interpreters and how they may be used. You have 3 different levels of interpreters. This puts it in the statute what those requirements are and what judges need to be doing. Of course, we're getting into a situation in the country we live in where we're all seeing more languages spoken, and sometimes English isn't one of them. But that's what this does. I'm happy to answer any questions.
Okay. We're on a bill. Do we have any questions from the committee? Do I have a motion?
Title sufficient, do pass.
Motion's title sufficient, do pass. All in favor, say aye.
Aye.
All opposed? That carries. Thank you, Senator England. Appreciate
you.
that. Before we move on to the next, I want to take the following up in block, and my motion will be that we set those aside subject to call of the chair. On your agenda, that would be House Bill under Civil Law and Procedure, House Bill 1155 and House Bill 675, and then under ad hoc, House Bill 1318. And so my motion would be that we set those aside subject to call of the chair. I'm sorry. Can you, I think my Senator Branning made that motion, by the way. Thank you, Senator Branning. Thank you. All in favor, say aye. All opposed? Thank you, Senator Branning. Okay. Next, we'll go to Civil Law and Procedure, Senator McCon.
Thank you, Mr. Chairman. There's a couple of bills here. We'll just start with that 246 bill. It is a real property bill, and what it says is pretty straightforward. It's clearing up a little bit of language in there that says the right of first refusal granted through a contractual agreement or any other written instrument or conveyance is extinguished upon the death of the grantee unless the contractual agreement or instrument of conveyance or memorandum specifically states otherwise. So what we're saying is that if it just says right of first refusal reserved for me, and it doesn't say anything else, then it's going to expire upon my death. But what it does say in here is if you put a right of first refusal for me and the chairman and the vice chairman, then that would prevail over my death. And that's the only thing we're doing in here is clearing up that language to say that unless it's unambiguous language on the face of that instrument, that's what it would do. It would extinguish upon the death of the grantee. I would entertain questions, Mr. Chairman.
before we do that, I will note to the committee, which I think you do know, that as you see on your agenda, all these bills have gone through subcommittee and have been done that. So the recommendation you see there on your agenda. So we're on the bill on the strike all. Do we have any questions on House Bill 246?
A motion will be title sufficient to pass strike all, Mr. Chairman.
Motion is title sufficient to pass strike all. All in favor, say aye.
Aye.
All opposed? Motion carries. Thank you. House Bill 685.
Mr. Chairman, this is another real property bill, and this is coming from our friend Representative Reynolds. This provides a single issue. Here's what we're dealing with. We're trying to be sure that after effective date that a person conveying interest to two persons who are married to each other and such properties are primary residence of the married couple, that the deed conveying such interest would create a rebuttable presumption that it is in joint tenancy with rights survivorship. Current language says that if it's two individuals and it does not have specific language on there that says joint tenants rights survivorship, then it's considered to be tenants in common. So the goal here is to say that if a married couple owns their property and they put in there, it's just one name or two names in there, there's a rebuttable presumption that it is in favor of a rights survivorship situation. Too often we have minors involved and we have a tragic situation and people didn't get their deed corrected. We're seeing that less and less, but it happens in real property law. So the goal is to try to create that rebuttable presumption to clear that up. I would entertain questions, Mr. Chairman.
All right. Any questions from the committee? Senator Turner Ford.
Thank you, Mr. Chairman. So as you mentioned, current law is if the language is not specifically stated that the individuals are joint tenants with right of survivorship, it is by default a tenancy in common.
That is correct.
So what if it's a situation, I think you may have mentioned this, where the couple is married, but both individuals or the other spouse is not on the deed? So are you saying that if just because they're married and lived together on the property, a rebuttable presumption of a joint tenancy is created?
There is according to the way it's written right here, I do read it where, no, actually I read it where it's conveyed to two persons who are married, that it would have to have both names on there, but if it did not have the right survivorship language on there, that currently it would be tenants in common, but the way that I read line 31, an interest in property to two persons who are married to each other. So that would be to both of them. Line 31 there on.
What if they don't intend to create a joint tenancy?
Well, I
And
believe
if this would be and I guess my question is pertaining to an incident where two individuals have married. This could be a second,
right,
a multiple marriage. They don't share the same heirs. Are we creating a joint tenancy just by virtue of the fact that they're married and live on this property?
if both names are on that deed, then we are creating that joint tenancy. Now, so kind of where I see this, where we're at right now is formerly you had to go in there and put the specific language of a joint tenancy in the deed. Now, I believe you would be changing the presumption. And if you wanted it to be tenants in common, you would have to put the clear language on the face of that deed of tenants in common.
And if the situation is one of the tenants is now deceased and one of the heirs is then trying to challenge this presumption of a joint tenancy, the level of proof that would be required, the type of situation that we're creating, and both individuals are no longer living to dispute or provide facts to the contrary. Is there a reason in particular that this bill is being advanced?
This bill has been brought up, and I don't believe it's a bad bill, and I'll tell you why. Because in my practice, I do see it, and like ideally, you've seen a lot of changes in the drafting of deeds since the 60s and 50s and 40s, where back then it was the tenants in common is what you saw more of. Now you see a lot of people, most attorneys putting in there the joint tenants right survivorship. You know,
And-
I believe this is just to clear up those few that are left out there.
And Senator Turner, forward to your question, and I don't obviously do as much real estate law as that, but it's a problem. You always find in the court cases that somebody hasn't put in rights of survivorship, or there's a question as to what it is, or they do it and it's, you know, it's tenants in common. And so there's, I think, the reason this is being advanced is to clear up this problem in the area of the law. And that's to Senator McConn's point, trying to fix that. And it's just creating a rebuttable presumption.
But isn't it, if you observe the law as it is currently, the presumption is if you don't have the specific language in the deed, then by default, it's a tenancy in common. And so what we're doing is changing the presumption to the reverse. Am I understanding that correctly?
We are, actually. This,
And
this bill would do that.
But
And
the
so-
qualifications, it says married. Okay,
Right.
so I think what the language is saying is married. The key is married.
I'll just share, there are some instances where I've spoken with couples and I know that this is, you know, their heirs are not the same and they don't want to disinherit either set of children. And so they just allow this deed to be recorded as, you know, they're just tenants, the property, they're tenants in common and there's no full right of survivorship language.
And I believe, Senator, I agree with you. And I think a studious attorney would clear that up in the drafting of it. Unfortunately, I'm afraid that there are some out there that don't do that. If you came to me and asked me that same question, I would put in there specifically tenants in common. And if you were going to do another deed where you wanted right survivorship, I would say not as tenants in common, but as full rights, joint tenants right survivorship. So ideally, I would like to see that on all the deeds. I mean, it would make it a lot easier for a practicing attorney that's doing the title work. But I'm bringing this up to the committee to consider. We've considered it some in the subcommittee, and I entertain any more questions on that, Senator.
Last question. Would this law apply to bills that have been recorded retroactively or is it going forward only?
After the date of this act.
Thank you.
Senator Hobson, you had a question?
Yes, sir. Thank you, Mr. Chairman. I think, again, I practice in this area some too, and I do think that most married couples would have and they expected it as a joint tenancy with right of survivorship. I think there'd be very few that would want the tenancy in common. They expect that upon their death, their spouse would continue to own the property. Usually it's homestead, maybe not always. Could be exceptions to that, as Senator Turner Ford had pointed out. I think this is a step in the right direction. My biggest concern is the effective date. Because I mean, we attorneys may know the effective date and that we have to tell people that, well, it depends on when it was, but a lot of people may not know that. I'm wondering if we shouldn't strip that and just make it that it's the rebuttable presumption is for any tenant, any conveyance that has two people that are married at the time, it shouldn't be presumed to be joint tenancy with right of survivorship. I'm wondering if
I guess my only
you'll comment
concern-
on that.
My only concern there, Senator, would be as we are running title work on these properties, if we now have this and we've taken away the effective date and say all previous ones is what you're suggesting, is that correct? Then that's going to leave a high burden on a title attorney to go and decide, well, was it right to survivorship or was it not? Where do you create? And it actually would go back to Senator Turner Ford. What evidence would you use to make that determination? I'm hesitant to say, let's go back and do it all the old ones, because I don't know what they did, intend at the time. I do agree that most people think when dad dies, it goes to mom and they forget about the kids because they don't know the intestacy statutes. But in this situation, I'm hesitant to go just open the door for all previous transactions.
So the effect is that anytime that you are looking at a piece of property, we're going to have to start saying, well, assume this goes into effect upon July 1, 2023. So, depends on whether or not that property was conveyed prior to July 1, 2023 or after July 1, 2023. That's going to be, everybody's just going to have to know that's the date.
Well,
When-
and let me
when you
make
look-
sure that I understood what you were saying was you would like to either change the date or just say it blanketly applies across the board.
Well, 10 years from now, if I'm doing title work or I've got a conveyance and somebody says, well, who owns this property upon? And I guess that's just something we as attorneys will have to know, but I think a lot of people in the general public would not understand. And that's, I mean, that's just part of it, that what date, what is the effective date? Everybody will have to know that effective July 1, 2023, the rebuttable presumption was that it was, from then forward, it's joint tenancy, rights of survivorship. From there back, it's tenants in common.
Yes,
And
sir.
and you just create a weird situation in the law that some folks, I guess it'll depend on when it was conveyed. I think most people, when they conveyed them together to a married couple, I'd be willing to bet that 95% of them felt like it was being conveyed to the spouse's joint tenancy, rights of survivorship, whether it said it or not. That's my experience.
And I don't disagree.
And I'm just trying to clean up. There may be 5 or 10% that thought it was going to be tenancy in common, and that's why they did it. And I guess those folks may not get their wishes. But if they wanted to wish, if they've got a specific desire, it's easy to put tenancy in common or joint tenancy.
Yes, sir.
And I
I
think
agree.
most people have done that. Anyway, the effective date is my concern, Senator McCon. Thank you.
Any other questions? All right, do I have a motion?
Titus Fish do pass.
Motion's title sufficient, do pass. All in favor, say aye.
Aye.
All opposed? The ayes have it. Thank you. Welcome to law school, audience. All right, House Bill 821, Senator McCon.
Thank you, Mr. Chairman. We've seen this bill before. Ladies and gentlemen of the committee, there should be a strike call on that one. There it is. I'm sorry. I didn't have it before me. We've seen this before. This was working through subcommittees over the last couple of years. We took if you see the proposed strike all here, this allows and it authorizes the Secretary of State's office to charge a different amount for an electronic notary pursuant to their promulgated rules. So right now, an electronic notary would cost substantially more than the $5 currently under statute. We have taken our language that was created in the subcommittee in the past, put in there that an in-person shall be not more than $5, and that electronic notary shall be not more than $15 unless Secretary of State's office makes a rule otherwise, but it can be no more than that $15. And that's because some of the software is costing substantially more to do the recording of those. But like I said, this was the language we pulled from last year, and we kind of came to some type of decision that it was better than what we had. We did take out the residency discussion that was in the old bill. So that has been taken out, and this is just about the amount of electronic notary fee. I would entertain questions.
Any questions? I have a motion.
Motion be title sufficient, do pass, strike all.
Motion's title sufficient, do pass. Strike all. All in favor, say aye.
Aye.
All opposed? The ayes have it. House Bill 1101.
Last bill here is the 1101. It was brought to us by the Secretary of State's office about some concerns. Now we require that you give an email address to Secretary of State's office when you do your annual reporting or when you create a new corporation, LLC, or anything of that nature. So I had some major concerns about saying that all notices shall be electronically mailed. We worked with the Secretary of State's office and Ms. Janice over there to come in here and put a provision where you can actually elect to receive your notices electronically. If you look at the language there, such a determination may be served either by electronic mail to the email address of the registered agent of the corporation or by first-class mail as indicated by the corporation. If you've created a corporation, you know that you do an electronic form. There's a spot in there. There's going to be a new form, new spot located in there that says, would you care to receive your notices electronically? If you mark that, then you have made a overt action to receive your notices electronically, and they will come to you electronically from that point. Everybody else will continue to receive it first-class mail. I'd entertain questions, Mr. Chairman.
Any questions? Anybody want to grill Senator McCon?
Title
No-
sufficient,
no
do
questions.
pass, strike all.
Motion's title sufficient, do pass, strike all. All in favor, say aye.
Aye.
All opposed? That carries. Thank you, Senator McCon, for your hard work. All right, I'm going to go to committee of one. We'll call up House Bill 276. This is the State Board of Physical Therapy. I don't mind saying, at the request of the State Board of Physical Therapy, we had filed a Senate bill. This is the House companion bill. The Senate bill is dead. And in short, what it's doing is if you look at line 68 to 70, I'm sorry, to 81, it is giving them subpoena power. There are many board, for whatever reason, the Board of Physical Therapy, which I think has been kind of reconstituted, doesn't have it. There are other boards in the state that have subpoena power, from the Social Worker Board, Nursing Board, Medical Licensure Board, Pharmacy Board, Psychology Board, Dental Board. I could go down the list. And so their request is to be able to properly regulate and properly handle their folks. They needed subpoena authority, and that language right there, everything else is current law. That language you see right there is what they've requested. So be happy to answer any questions. Motion's title sufficient, do pass. All in favor, say aye. All opposed? The ayes have it. All right, House Bill 485. Many of you are probably familiar with this one. This is the sexual assault kit bill that has come over from Chairwoman Cockerham. In short, the sexual assault kits are what's used when law enforcement and others are investigating alleged sexual assaults. And through different reports, there's various sexual assault kits that are not being investigated, or for whatever reason are not being handled. What we want to try to get to these, you have before you a proposed strike all, and the difference between the House bill and the proposed strike all is that at the end of the bill, you have a task force. I'll refer you to that. Okay, you have a task force, the Sexual Assault Evidence Accountability Task Force, and the strike all adds 2 physicians onto there. We have that. Thank you. Lines 232 to 235. Is that the regular bill? The strike all. Okay. All right. All right. 203 and line 203. Okay. So we have any questions on the bill? Do we have a motion? Motion's title sufficient, do pass, strike all. All in favor, say aye. All opposed? Motion carries. All right. Next on our list is House Bill 1020, which many of you are very familiar with. I want to, and I also see the Jackson delegation here. I have a couple comments and then we'll go through the bill. I would like everybody, when we go over the bill, focus on the bill, because a lot of work's been put in it from the Senate side. And I will refer people to the op-ed that was put out by Representative Chairman Trey Lamar. And if you'll notice in there, he said the sole goal of trying to get somewhere is for the public safety of Jackson. And I think that's what we are trying to do. I'll go through the bill in a minute. We do have a strike all. Before you is a proposed strike all. And I'll highlight it this way. The strike all takes out the appointed judges, all the appointments that came over from the House bill. The strike all takes out what's known as the expanded CCID. And as background, I think, and I need to inform the committee because it's become clear through this debate that really people don't know. And the Senate for the last 2 years has funded prosecutors and prosecutors and judges to help the city of Jackson. And those prosecutors and judges have been doing their job here at the state capitol. Some of you may remember, and I think some others have stated that from the Senate floor that we're helping them in last session. I know Chairman Hobson has handled the appropriation for this. So for 3 years, or I think approximately 2 years, we've been doing that. The effect of the strike all that's before you is we are codifying what we have been doing as a state legislature for the last 2 years. And we are utilizing the system, and I personally have spoken to the district attorney for Hinds County, who I will state I think is doing a good job. I have numbers, I have data from them, and what has been shared with me is that with the assistance that has come forward from the state to this point, the caseloads and the criminal cases in particular are being addressed, and it's working. So to go through the bill, Section 1 says there should be 3 temporary special circuit judges. This is important. That language is important because they're temporary. That is in reference to or similar to what we've been appropriating through the appropriation process. With powers and duties under the Constitution, under subsection 2, 2 temporary special circuit court judges for the 7th Circuit Court District shall hear only criminal matters. So what does that mean? That means 2 judges can hear civil and criminal. 1 judge hears only criminal. 3 judges, everything, 2 judges, criminal. In other words, a rocket docket for criminal cases. And that's us lawyers know what that means. If you look at line 47 in section 1, 15 days after passage of this, the Chief Justice shall appoint or reappoint, by the way, the judges in that position. How things have been operating to this point is the Chief Justice has appointed those judges who are handling the cases here. So this is no different from what we've been doing for approximately the last 2 years. Then, if you notice in line 53, it shall stand repealed December 1st, 2026. So the state is funding these judges until December 1st, 2026. What we're doing right now is you're subject to the appropriation process every year. Section 2, 3 full-time legal assistants in the 7th Circuit Court District. Those are assistant DAs. Those are what as many of you know, there is a DA bill going through requesting assistant DAs. This is the 3 that they've requested, that Hinds County and the 7th Circuit Court has requested. Section 3, public defender, 3 full-time assistant public defenders. The House in their bill had public defenders. The state will be funding the public defenders. Section 4, and a little bit of background, many of your criminal cases go through the county system, your county prosecutor. And so under section 4, the county attorney, I should say this, section 4, subsection 1 is already standard language in the code. That is actually Harrison County for those. Subsection 2 you see is new language. We're simply doing what Harrison County has been doing for years. The county attorney in Hinds County can appoint a second, what I would call deputy county attorney. 2 of them, thank you. Thank you. 2 of them. You will notice that this subsection will repeal on December 1st, 2026. Okay? That means the second county attorney, that position, not your regular county attorney. The state pays, it's good to have the appropriations chairman on the committee, but the state, the plan is the state. Oh, yeah. Okay. Thank you. If you look at lines 82 and 83, it says funds specifically appropriated by the legislature. Section 5, this is currently in Hinds County 7th Circuit. There are 4 judges. That's language is already there, starting at line 101. Starting January 1st of 2026, there shall be 1 circuit judge for the 7th Court District, and shall be elected from the areas. The judge, yeah, in addition to the other judges. So starting in January 2026, Hinds County 7th Circuit Court will have an additional judge. I will note for everybody in the committee that in 2025 is the elections, is that right? For 2026, okay, is judicial elections. 2026, yes, that's right. Okay, thank you, thank you. If you look at line, okay, if you look at lines 130, so many don't know, but your judges in different places, including Hinds County, run, and some people call them places. In the code, they're called sub-districts. So if you look at line 130, you're creating a separate new sub-district called Sub-District 75 in Hinds County to be determined before January 1st of 2026. Section 7, this is taking the language from the House bill with the body worn cameras, where they shall all wear it. Section 8, okay, Section 8 through really all of Section 8 is language that the Senate has already passed dealing with the Capitol Police. The one difference is this, in this language, the jurisdiction of the Capitol Police is being extended to all of the city limits of Jackson. Also, starting at lines 228 to 229. Oh, I'm sorry. What's the language? Yeah, sorry, 214. The commissioner of DPS and the city of Jackson shall enter into a memorandum of understanding that's mutually beneficial to both. The execution or failure to do that does not change the jurisdiction of the Capitol Police. In the event that the memorandum is not signed, the Commissioner of Public Safety, any dispute shall be resolved in their favor. Then, right. Okay, if you look at Section 10, except for Section 8 of this act, it shall take effect of being enforced from July 1st of 2023. I will note that Section 8, which is the Capitol Police, will take effect should this become law on October 1st of 2023. That's to give, that's to get higher officers. That's to give time for them to do it. So with that, that's an explanation of the bill. I'll be happy to answer any questions. Senator Simmons.
Thank you, Mr. Chairman. You noted at the beginning of your presentation of the bill that the Hinds County delegation was actually here. Did you speak to the senators from the Hinds County delegation about these proposed changes?
I did. I informed them. We discussed it. I will let them, if should they want to, comment on that, but yes, I did.
Okay.
And I was certainly glad to do it. And it's not that there's any secrets, but the Hinds County Jackson delegation knows for the last 2 years that we've been funding these positions through the appropriations process. And I'll be upfront about it and say, they've worked hard for their constituents to bring a safe community to Jackson.
And so section 1, as you mentioned, we passed the bill and we actually have, if I'm not mistaken, 4 special temporary judges appointed by the Chief Justice already in the city of Jackson, helping with the backlog of cases, correct?
That's correct. We have 5. Okay, yes, we have
I thought it was 4.
We have 4. There are 3 that are working, and there's 1 vacancy for, I'm not sure that they're trying to fill that, doing that. And by the way, that's been done, as I said, through the appropriation process.
So it's the language in section 1 in the strike all, is this language adding additional judges, or is it incorporating what we already have, but adding 1 more? Because if you add the 3 and the 2 in subsection 1 and 2, the total is 5. So I guess my question is, are we adding 1 more special judge, temporary judge to the 4 that we are already funding?
In consultation with the Lieutenant Governor's office, the intent of this language that you're referring to is to add these to those that are being funded through the appropriations process.
So would it be a total of 5 should this bill become law?
Right. I'm sorry. Let me put it this way. It's a total of 5 to add those to there, and that we fund them through 2026.
Okay. Should this bill become law?
To be honest, I don't know that any place needs 13 judges or whatever.
Okay, I just want to make sure that the intent is that to add just 1 more temporary judge that is already being funded by the legislature. That's my understanding.
Okay. Best way to put it is it codifies the 4 that the legislature's been funding and adds another one.
Thank you. For section 2 and 3, you said you did speak with the Hinds County District Attorney Jody Owens regarding the additional ADAs and also the additional public defenders.
Yes, and also this committee and the Senate passed the prosecutors, what is known as the prosecutor's request DA bill. And in that bill, the Hinds County had requested 3 additional assistant DAs.
I didn't see it, and if I overlook it, I apologize, Mr. Chairman. At any point in time, would these be permanent ADAs, additional ADAs, and permanent additional public defenders, or are they temporary? And if so, when would it end?
The legal assistants, as they're termed in the statute, they're permanent. And I should go into, it's not in this bill, but in the different bills that address the legal assistance code. Under that, the state funds a certain amount of ADAs, and the counties, if they so choose, fund a certain amount of ADAs, and we determine how many the counties can do. That's what part of judicial and DA redistricting is as we go through. So the intent is that, yeah, in section 2, that it would be permanent, and the state would be paying those.
And as it pertains to section 3, based upon our current public defender structure, if you're not the state public defenders are funded at the county level. And as I read the language in section 3, these 3 additional assistant public defenders will be funded by the state.
Correct. And I need to point out that as the bill came over from the House, what the House had proposed was that public defenders go through the state capital program and that money go there. And so this is, and you're correct, depending on the county, counties have a county public defender system and some counties use contract public defenders. And so those are the ones that do that. So both the House and the Senate bill, yes, are talking about funding public defenders.
By the state,
I'm sorry?
by the state, the state will fund it.
Yes.
Okay, thank you. And I think one or two more questions. And you already pointed out the line 82 for the additional 2 deputy county attorneys for Hinds County. Well, of course, the elected county attorney is paid for by the county, but the 2 that are mentioned in line 76 through 86, which is section 4, it would be funded by the legislature in lines 82 and 83.
Yes,
Okay.
but that subsection expires December 1st, 2026.
Okay. I see that. And starting at line 101, I think this is an error because the next judicial elections will be in 2026. And so the term for all judges elected in the November 2026 election will start January the 1st, 2027.
Council's pointing us to section 9 of the. Okay.
257. Okay, I see. So-
Yes,
So
Senator
what,
Simmons, I'll let council shed some light on that.
okay.
The
yes, sir.
language on line 101 references January 1st, 2026 to give the authority for the candidates to file in the election. That would be the filing
Oh, I see.
date. And then if you look at section, I believe it was section 9, that lays out the term beginning a year later.
I see. So for the new elected judge in Hinds County, the qualifying will start January 1st, 2026 and end February 1st of 2026, correct? Which is qualifying deadline. But any judge that was elected in November, the term you said will start on line 257, January 1st, 2027 for 4 years.
No, I think that the intent is under section 9 is that the new judge comes in January 1st, 2027 and serves a full 4-year term.
I got you.
And Senator Simmons, let me, with the judges, the prosecutors, well, I'll take the prosecutors out because those are permanent. With the judges and the county prosecutor, this may be a bad term, but I use it. We're triaging the cases and the court load and the court system in Hinds County till 2026. If this passes, we're doing that. And then as we go forward, you'll have, yes, Hinds County will then have its an additional judge to what they have now.
Got you.
Right,
But-
and the permanent assistant DAs.
So the temporary judges will fall off. We'll have a permanent elected judge and the additional DAs and additional public defenders will remain. Based off the language.
Yes, I will say this, though, this, as you know, this is all subject that my assumption is that the House will end up in conference. So all those things will have to be discussed. That being said, should this pass and pass the floor, this is the Senate position going into conference.
Okay. And my last question is, the Senate considered Senate Bill 2343 earlier that this session that dealt with the CCID. And in your beginning explanation of the bill, Mr. Chairman, you said that this bill does not, or we remove the language that came over from the House regarding the expanded CCID, correct?
That's correct. However, the strike all, as was in Senate Bill 2343, expands the jurisdiction of the Capitol Police to the the city limits of Jackson.
Thank you. That's all my question at this time.
Thank you. I think Senator Blackman had a question.
Yes, thank you, Mr. Chairman. Under section 1, where you're saying that there would be no limitation whatsoever upon the powers and duties of the said judges, and you were representing that this was what they were doing presently, those judges that are appointed by the Supreme Court.
No, as set up in the appropriations process through the legislature. Yes, that's right. They're handling those. Yep.
It's my understanding from communicating with those judges, those elected judges, that they give cases to those appointed judges. And if they choose not to give them cases, then they can't handle any of the cases that have been assigned to them. But now we are saying that they can just get anything.
I don't know if that was the intent. I will say this from what my understanding of what you're talking about is that when this was set up, I guess approximately 2 years ago, there was, let's just say everybody wasn't singing from the same hymn book and people had to get involved. My understanding is that's been worked out. And so, yes, the current judges then send over to the what I'm calling the currently funded special judges. And so I don't think there's any, wrong intent in that. And what this is saying is actually just the constitutional part of it. They can see civil and criminal, whereas if you look down at line 44, it says judges shall only hear only criminal matters. And the idea behind that is to create what I call a rocket docket for criminal matters.
But if we're trying to place into law what the judges are doing currently, then would it not be that the 4 elected judges continue to give to the specially appointed judges those cases that they want to give to them?
No, ma'am, because the judges that are being put here would have the same authority as any judges in any circuit court. And I'm sure you're pretty much familiar that when there's 3 judges or 4 judges or 5 judges, you have a senior circuit judge and they all work together for the benefit of the district. That's what's contemplated here.
Okay, but when in your explanation, you represented that it was just a continuation of what those judges were presently doing. And so in effect, this is not a continuation. So my next
Well,
question,
you may see it that way, but I don't see it that way. We're giving temporary special judges to the 7th Circuit Court District, and the judges, who are all adults and lawyers and all that, can decide how they want to handle those things should this become law.
okay, so presently, the cases that come to any of our circuits, they are supposedly randomly assigned to a judge from the administrative office of courts.
I don't know how it specifically works in Hinds County. I can tell you as a practicing attorney that yes, when you file cases, also criminal cases, they're randomly assigned.
Okay, so now these judges will be in the rotation for getting randomly assigned cases?
I don't, again, they're temporary special circuit judges. Okay. Yeah, in the language that you're talking about, from what I understand, is not in the appropriation. The issue, the reason it got to that point was, if you want to really, from what I know, and you get into it, is that when those judges were appropriated and appointed by the Chief Justice, that there was pushback from the current sitting judges. And so they weren't willing to work with the special judges. So the legislature wants a safe Jackson. Now, the system that you're describing is what came about, from what I understand, by adults getting in a room and working through it. So I suspect, should this become law, that that's what'll happen, and they'll all work together for the benefit of the citizens of Hinds County.
But we're now carving out for a circuit judge in the 7th Circuit, where they will only handle criminal cases.
That's what lines 41 to 44 says. Yes, as I said, it's a rocket docket for criminal cases. And Mr. Owens, the DA, when I met with him, stated that they are handling cases from as far back as 2015 and 16. And if we want to get a handle on this, then we need cases going to trial and going and being handled by a docket, and that's why we've done that.
And so the Chief Justice is going to appoint this criminal judge. And then it's when it's the DA going to decide what cases will be going to this criminal judge? Or again, is it going to be going through this supposedly blind process where you get this one, then the next one comes up, I get, then the next one, Hobson gets, then the next one, Turner Ford gets?
You know, that I think those things just need to be worked out. But as far as I know this, talking to, again, the DA in these cases, they're trying criminal cases before these special judges that we're already appropriating.
Okay, my next question is on lines 48 and 49, where you say the Chief Justice shall appoint the judges authorized under this section. If throughout the state, if a judge should retire before his or her term is up, or if forbid one would die, does our Constitution allow the Chief Justice of the Supreme Court to make that appointment?
I don't know.
I think you've been here, what, about 18 years? You've been here 18 years.
Yes. I don't know.
Does not the governor get the opportunity to make appointments if an opening occurs?
Honestly, Senator Blackman, I don't know. I don't know.
Would you take my word for it that the governor makes the appointments if a vacancy occurs?
I'll rely on counsel
Counsel,
when we need to get to that point. And the Constitution, the wording of the Constitution and all of that. And that's just because I don't know. I mean, we'd have to go look at it. And the council's saying
Sean Tyndall was a senator here a few years ago, and an opening came available on the Court of Appeals. Who made that appointment for him?
well, that's the Court of Appeals. And my understanding is, well, that certainly was the governor made that appointment.
And we had.
And then, you know, he's done a good job. He did a good job on Court of Appeals
And we
and had to face election.
in our circuit court district, one of our circuit court judges was appointed to the Court of Appeals, Judge Finger. And then the governor then appointed a replacement in our circuit court district for that judge, that when Finger ascended to the Court of Appeals through an appointment from the governor.
Senator Blackman, we're on the bill before us. I don't know how that line of questioning relates to the language that's in the bill. And so I'm not sure what that's about, but we have other committee members, we have a full house, and we need to get on to the agenda. So
It's related to the constitutionality of the Chief Justice making appointments when the Constitution does not give the Chief Justice that authority, but I will move on.
Well, thank you.
On line 138, where you say, what this bill says that the body worn that the Office of Capitol Police shall wear on their uniforms, the body worn cameras. At the proper time, I would like to offer an amendment for if there's a failure to, for the body worn camera not to be on at an arrest.
Okay, at the proper time, we'll entertain your amendment. Do I have questions?
I
Sorry.
haven't finished my question.
Okay,
Thank you. On lines 220 to 223, it says that in the event a memorandum is not executed, then any dispute would be in favor of the enforcement functions of the Office of Capitol Police. What, why is that not a mutual, what if it's the Capitol Police chief is refusing to execute the memorandum? If he refuses or she refuses, then why can it not also be in favor of the city of Jackson?
well, somebody, first of all, in the law enforcement space, if you go back and you look at where things happen, at certain points, there tends to be a question of who's in charge, okay? So with this language, and by the way, this is language which has been used in previous Capitol Police legislation, somebody needed to be in charge because you have problems when that doesn't happen. It is well documented in the media and it's well documented in the court system that there's been issues with the city of Jackson and particularly the mayor entering into contracts. And so that language is to provide for the safety of the citizens of Jackson so that they are no longer caught, at least in this scenario, caught between disputes between the city of Jackson and I would say the mayor and Capitol Police. We're trying to create a safe place, not only for the citizens, but also for people who come here for our great capital city.
And at the proper time, I'd also like to offer an amendment on at lines 230, 231, where you're saying that you have to receive written authorization from the chief of the Capitol Police or the commissioner for if there's any kind of event which is going to take place on any street, a sidewalk of any property that's leased or owned by the city, by the state of Mississippi.
At the proper time, your, excuse me, your amendment will be entertained.
I think those are all of my questions.
Okay,
Thank you, Mr. Chairman.
we have other questions on the bill? Other questions? All right, now's the proper time for your amendment, Senator Blackman.
Thank you. And I'll let council tell me where I need to have this. But I would like lines 136 to 138 for failure to have the body worn camera on during an arrest, that police officer shall forfeit pay for 3 months. And this is trying to equalize in some shape, form, or fashion for the person who is being arrested. And that's the amendment.
Okay, can you restate your amendment based on where you're trying to insert that?
at the end of line, on line 36, after that period. Wouldn't that be correct? For failure to have the body worn camera on, that Capitol Police shall forfeit pay for 3 months. Yeah, the recording device, whatever they use.
All right, you've heard the minute. I'll just state, I'm not really sure. Yeah, Senator Hobson,
Question, Mr.
we're on the
On-
amendment.
On the amendment, is that provision in the law anywhere else in the state about the forfeiture of pay? for
Not that
body
I know of.
cameras?
No, not that I know of. And that, by the way, this language is from the House too, and they didn't bring anything like that over.
Thank you.
May I respond to that question, Mr. Chairman?
Sure.
I don't think that we have this language for this bill in any jurisdiction in any other part of this state. So we're on new ground.
Any other questions on the amendment? I would ask the committee, I would state on the amendment that as Senator Hobson mentions, there's no other language like that. Having the body, that's an unfair, I would think that's an unfair position to put the officers in. And actually the agencies, the police agencies, they have their own operating procedures and how they dictate and hold their officers accountable. So I would ask you to vote against the amendment. So all in favor of the amendment, say aye.
I get a chance to close.
Yes, yes, you may close.
Thank you. Again, this entire strike all amendment. We have 82 counties in the state of Mississippi and umpteen cities, towns, villages, and unincorporated areas. And we do not have this kind of law for any of those entities. And I love the city of Jackson. I was born and raised in the city of Jackson. So I'm very grateful that this legislature is taking an interest in the city of Jackson. But I do believe that there should be some kind of penalty. It doesn't have to be 3 months, but that's the starting point. There should be some penalty for your not having that camera on when you're making an arrest. If we are trying to protect the citizens of Jackson and we are trying to protect all of the visitors who come to Jackson, then I think that what's good for the goose is good for the gander. And the police officers should have some kind of accountability. Thank you, Mr. Chairman.
Thank you. Excuse me. Thank you. You've heard that. All in favor of the motion, say aye. I'm sorry, the amendment, say aye.
Aye.
All those opposed? The noes have it. Your next amendment, Senator Blackman.
Thank you, Mr. Chairman. On line 230, where it's 231, where it's saying that the Capitol Police, that written authorization from the chief of the Capitol Police or the commissioner required prior to the approval of any event, I would like to add, and it cannot be unreasonably withheld. And this goes to prior restraint when you're trying to have freedom of assembly, First Amendment protection. You don't want someone to withhold authorization for a period after the time that your event is occurring.
And which line is that?
231.
31. Okay. Unreasonably withheld. Okay, you've heard the amendment. Does anybody want any questions on the amendment? Anybody want to speak on the amendment? Okay, those in favor of the amendment, say aye.
Aye.
Those opposed? Chair's in doubt. ask for a show of hands. Those in favor of the amendment, say aye. Those against? The motion, I'm sorry, the amendment fails. Okay, any other questions? We're Senator Simmons.
Mr. Chairman, it was an oversight. I do have one more question. The language starting at line 101 for the new elected judge for Hinds County, that would be in sub-district 7-5.
I'm sorry, what's the question?
My question is that new elected judge that will run in January of 2026, is there a language here that requires that all candidates to be from Hinds County?
Sorry, Senator Simmons, I know you're interested, but you don't live in the
No,
seventh
I'm not
circuit court
interested.
district.
I'm not
so-
interested. I'm not interested. I just want to make sure, because I know throughout the state, and I know Chairman Hobson knows this, some districts require you to have to live in the actual sub-district. Some districts require, even if you live in the judicial district, you can run in any of the sub-districts. And so I don't know what the law is
Right.
for the
This
seven.
doesn't change, this language doesn't change any of that. It's what's right before you.
Okay, so I guess for the council, it's the law in the Seventh Circuit, does it require you to have to live in the sub-district? Or can you actually run if you're in the entire Seventh Circuit?
There's nothing in the strike all that talks about that.
Yeah, but the strike all starting at 130 and 1 through 132 creates a new sub-district. So I'm just trying to find out.
Council may be able to assist you.
Okay.
with that.
I looked at those two sections. I didn't see any requirement one way or the other as to residency. It would be just as otherwise provided by law, as far as I know. There may be another requirement somewhere separately on the Seventh Circuit. But those are the two primary code sections for the Seventh Circuit, and I didn't see anything in there
So whatever
to say one way or the other.
so the intent to council is whatever the requirements are to run for judge in the already 4 sub-districts in the Seventh Circuit, the requirements would apply for the newly created sub-district 7-5.
That's correct.
Thank you.
Yeah.
Thank you. Senator Barnett, you have a question?
No, sir. Amendment at the proper time.
Now's the proper time.
Thank you, Mr. Chairman. Just going back to section 7 of the bill, where it talks about the cameras. I would just like to add an amendment that would start on line 134 or 135 about the body cameras and patrol vehicle cameras that shall be worn and operational or on while on duties. And where it says the body cameras means devices that are to be worn by police officers, I would like for patrol vehicles to also have those devices and not simply say that shall be worn, but shall be on and operational while they're on duty. And I asked for that amendment as a former mayor. This was some of the things that we implemented years ago, and it protected our police officers when they had to bring those things to court. By their camera, we had car cameras and body cameras. And not only did they have to be worn, but they had to be on and operational while they were on duty and in uniform. And that's just what I want. That's what I would like for the amendment to say.
If I may ask, what line, so you're adding vehicle cameras? Is that what you're doing?
I would like to add vehicle cameras as part of this. And I would like for, instead of the language, instead of it saying that the body camera and or if we add the vehicle camera, to not just only say shall be worn, because I can put it on, but I don't have to turn it on.
Okay.
And I would like for it to say that shall be on and operational while on duty.
If council can state how you have the.
I can read it back. So it's beginning on line 133 and then going through line 36. The Department of Public Safety shall issue all patrol police officers within the Office of Capitol Police body worn cameras and control vehicle cameras that shall be worn on the uniforms of the patrol officers and shall be affixed to patrol vehicles that shall be on and operational during patrol.
Yes.
Do I have questions on the amendment, Senator Hobson?
Thank you, Mr. Chairman. Do we know what the cost, I barely know what the cost is on the police officers. I know the commissioners come to see me about a rough estimate on what the cost is for the uniform body worn cameras. We don't have that finalized yet. What cost is it going to be for the additional patrol car cameras?
So Senator Hobson, I'll be honest, that may have been provided, but I don't have the cost of the body worn cameras. And I certainly don't know the cost of the vehicle cameras.
And is there a mechanism? Do you know, and I may need to get with the commissioner on this, what the mechanism is in place right now, what regulations he's got for implementation of the vehicle cameras?
I'm sure there are, and they may actually already have them. I don't know. I mean, this is a question that I think is for the Commissioner of Public Safety. So I don't have that information, but I think it's good information because we, as is Capitol Police, we're going to have to fund it, the legislature. Well, maybe that's something that the parties could work in their memorandum of agreement that's in the bill between JPD and them.
Well, I think
Cost sharing agreement.
I think based on this wording, if I'm not incorrect, counsel, is that this would be the state DPS, correct? This is Department of Public Safety, so it's going to be the state, not the city of Jackson. Anyway, thank you, Mr. Chairman.
Okay. Any other questions on the amendment? Any questions on the amendment? All right, all in favor, say aye. All opposed?
Sorry.
All opposed? The noes have it. Senator Simmons, last question. We've got other agenda items.
Thank you so much, Mr. Chairman, for your patience. I do have a question about the special judges. Are the special judges required to be from Hinds County?
7th Circuit Court District.
Judges in section 1.
Right, 7th Circuit Court District.
No, it says where they should be appointed, but we know we are talking about the appointments to the 7th Circuit Court District, but I'm saying, are
let me say this. I'm sorry, I maybe didn't understand your question. What the bill calls temporary special circuit court judges, no, there's no language that says they have to be from Hinds County. As is the case, as we spoke about, the Chief Justice has made appointments. The Chief Justice operates, and this goes for conflict cases, this goes for cases throughout the state, what I would call a pool of judges. And so the idea is the reason it's not limited there is so these are special temporary judges so we can get boots on the ground, so to speak, to get this going. Whereas to the permanent judge that we've talked about, they have to be an elected from the 7th Circuit Court District.
Thank you.
Thank you. Senator Branning has a motion. Motion is title sufficient, do pass. You've heard the yeah, as amended. You've heard the motion. All in favor, say aye. All opposed?
No.
The ayes have it. Thank you for the discussion. Appreciate it. We'll call up House Bill number 111. County court jurisdiction for termination of parental rights. This is Representative Jansen, who's here. He's going to explain. It's the bill itself, which is behind your proposed strike all. And I've spoken with this with Representative Jansen about his bill. The strike all that is before you is putting in the language of the statewide county court system and dealing with youth courts and Senator, oh, I've promoted you. Representative Jansen, you may explain the bill to the committee.
Thank you, Mr. Chairman. This bill addresses jurisdiction as far as TPR cases are concerned. A couple of years ago, the legislature granted TPR jurisdiction to those county courts exercising jurisdiction over abuse and neglect cases. Subsequent to that, a case came down from the Supreme Court indicating that perhaps that jurisdiction only applied to those involuntary TPR cases. However, our youth courts have consistently been approving surrenders and involuntary TPR cases. So this just clarifies that that TPR jurisdiction with youth court falls for both voluntary and involuntary cases. That's a brief explanation. And then Senator Wiggins has a lot of other stuff in it.
Thank you, Representative. And I will state that the strike all will have, I think it may have been oversight, and having talked to Representative Jansen to have his language as well as the statewide county court system. And we've talked about that. That came from a commission, the Supreme Court Commission, to try to get a handle on the jurisdictions of our youth courts. And so that's the bill. Do I have any questions? Senator Turner Ford.
Thank you, Mr. Chairman. I think this is the language that we passed out of the Senate, and I believe I raised questions about there not being any overlap between the Chancery Court districts and these proposed county court districts.
Right.
Will there be any efforts to realign these districts to make them more harmonious with what's in place?
I will tell you the idea behind this is to get it to conference and to work through that. I know that what you have before you, that those were recommended by the Supreme Court Commission. I've heard talking to different people that would be, there needs to be some changes. So we're willing to do that. Yes.
And if I may ask, when was this recommendation from the Supreme Court
About
Commission?
2 or 3 years ago. And it's been supported by many different ones, but there's been some folks who had some questions about it, not necessarily what we're trying to do, but just the logistics.
Thank you.
Thank you. Any other questions? Senator DeBar?
Thank you, Mr. Chairman. Did you indicate that this would go to conference? This will go to conference for sure?
Yes.
Okay, because I had some questions on
Right.
jurisdictional things I need to get
Yeah,
with you, then,
if-
if that's okay.
That's right.
Thank you.
Yes.
Mr. Chairman, just a quick note there. There definitely seems to be some differences in numbers of districts in there. So as it goes to conference, maybe we need to look at those
We will. Yes.
because they don't correspond throughout the bill.
Right. And I acknowledge to the committee that it needs to be updated and look at that. Any questions? Do I have a motion? Motion's title sufficient, do pass. All in favor, say aye. All opposed? Ayes have it. Okay, I'm going to ask that we're going to skip over the remainder under committee 1. We're going to go to ad hoc and Senator Boyd. Yeah. And we'll, House Bill 510.
Sorry. I think you've got your packet there in front of you of ad hoc legislation. We'll go to Senate Bill 510. I will tell you, I want to start off by, there were some questions. This is the same bill that we looked at. And we have kind of taken off the name. We did that in subcommittee yesterday. This is looking at the responsibilities and the rights of foster parents as they care for the children in foster care. I want to start off by first thanking the Attorney General's Office, Commissioner Andrea Sanders and Shannon Warnock of CPS, and really thank the work of the Conference of County Court Judges that have worked with us in crafting a piece of legislation that they feel like will benefit the children that they are taking care of in their custody. I particularly would like to thank Lee County Court Judge Stacey Bevel and Madison County Court Judge Stacey O'Neill and Judge Edwin Hanna for making sure that we were communicating with the county court judges on these particular issues. The committee, proposed committee strike all that you have in front of you incorporates many of the changes that I know some of you said that your judges had with the piece of legislation. We have worked with these judges. We have also worked with the advocates that brought us this bill to begin with. And so you'll see the changes that in the strike all from the original bill. We already had language in our statutes that dealt with the rights of foster parents, but we've explicitly spelled out, really beginning at line 304, we spelled out the notifications that foster parents need to have, advance notice of meetings, because we have some courts that and CPS workers that are giving a lot of advance notice, making sure that the families are very engaged, know about their IEP meetings, knowing about a lot of this. But we have other jurisdictions where that is not the case. And so we have a great frustration among our foster parents of really being.
Senator Boyd, can you, it's hard of hearing. Can you?
Okay. We have a great frustration of some of those foster parents, and we've heard from a tremendous amount of them across the state of not having basic notifications of IEP meetings, doctor's appointments. Also too, because there's a lack of uniformity in how these youth courts operate, sometimes when the foster family wants to be able to give the judge information in a foster care case, they're not permitted in the courtrooms. This would allow them to be present in the courtrooms. It doesn't give them, it doesn't give them the right to an attorney or anything like that. It gives them, which I know has been some issue with some prior language we had, but it really puts them being able to communicate with that guardian ad litem, gives them a right to talk to that guardian ad litem. And I know most of you with the courts that you operate in can't believe that this is actually not the case, but believe it or not, that is the case in some jurisdictions. So this is why we've worked with our youth court judges, our county court judges, and making sure that we put these obligations in place and the reason that we want to do this, there was a case that came up just this last week where probably it was kind of an extreme case with children that had been in foster care for a number of years, really basically their whole life. They were 4 and 6 years old. And there was a hearing done that really changed the placement of that child had that foster parent been able to be in that courtroom and provide basic information to that judge. I think you would see a completely different outcome where children's 4 and 6 who had been in custody of the state their entire time would not have been jerked out of that foster family's home and put in a completely different placement. It was a pretty extreme situation. And that's where the communication failed. So this really makes sure that that communication is placed with the youth court judge, knowing what's going on in that foster child's life. This also helps the foster family facilitate when reunification is the goal. It helps them facilitate visits with siblings, and it puts the ability to really do that. So additionally, we have put some notifications in. You would not believe the foster families that we've heard of that did not know that those children were entitled to some of the free and reduced lunch programs and different things like that. So this puts an obligation in here, and it also makes sure that when a child comes into your home, within at least 15 days, you can kind of receive a outline of their information form, because we have parents that were not being given those information forms. So they did not know sometimes about medications and counseling issues and different things like that. So this really just outlines just basic things that families need to take care of these children. and how they get reimbursed and different things like that. It also says the department is going to develop a grievance procedure, and they do have a grievance form they are working with on that. So this really just puts those things into place. So we also have added in here, as you know, the Senate passed a task force and foster care and adoption. So we want to make sure, as of yesterday, I think they have, as of yesterday when we met, maybe that bill had not been referred. It has been referred by the House now, but we have placed this language in here that has to do with that task force as well, which is the 17-member task force, because we basically just skimmed the surface this last year as we were doing our hearings on all the many different issues that were needed to be looked at and addressed with. Issues that right now, like our state treats abuse and neglect the same way. Many other states, they've broken up those issues and they treat them differently. So those are things that really that this does. So I'm happy to entertain questions on this bill.
Thank you, Senator Boyd. A lot of hard work. Any questions on the bill? Senator Hobson.
Thank you, Mr. Chairman. There was an amendment, I think, Ethan, council, we made in committee that's not in there, but just wanted to reflect that starting on line 328 and following, there should be a provision there that says unless ordered by the court in case of the foster parent hearings. There's some reason not for them not to be there. So if that would be reinstated, I just want to make sure that's an amendment.
Yes, you understand. That's
I move
an
adoption.
oversight. It should have been talking to council.
And I move adoption. Thank you.
Any other discussion?
I have a couple of amendments, Mr. Chairman,
Okay,
and these are,
state your amendment, please.
okay, they are,
On,
he said it was incorporated.
well, I think, I'm sorry, yours is already in there based on what council. Yes.
Thank you, Mr. Chairman, and as Senator Boyd informed the committee, she spoke with my youth court judge, and there are just a couple of items that I see. She sent me the same thing that she sent you. On line 341, the opportunity to request, and she wants inserted from the youth court permission. And on line 362, where it says retain the right to advance notice, she inserted a reasonable advance notice. Those are just two technical.
Anybody want to speak on the amendment? Any questions on the, any
I would
questions?
consider those friendly amendments. I think they just got left out. Senator Blackman, thank you in drafting. So,
Okay, you've heard the discussion. All in favor, say aye.
all right.
All opposed? Amendment carries. You had another amendment, Senator Black?
So those for the
Okay.
two.
All right, we're on the, any other discussion? We're on the bill. I have a motion. Motion's title sufficient, do pass as amended. All in favor, say aye.
Aye.
All opposed? The ayes have it. Thank you. Next bill, 533.
The next piece of legislation before you, if you will flip on over to, this has to do with home studies. And this legislation that came over from the House, we had kind of looked at this issue in the Senate. There had been some proposal that we really really kind of do away with home studies when basically do away with home studies if it doesn't, the judge did not feel like that it was necessary. Talking with CPS and our youth court judges, we are proposing that unless the court determines that the home study is not necessary in the case of an adoption by a step parent or a relative, or in the case of an adoption in a foster to adoption placement, because they've had multiple visits by CPS at that point. So talking with the youth court judges and talking with CPS, we are just going to give some very narrow exceptions here for right now. So that would be what we are proposing in that legislation.
Hey, any questions? Any other discussion? Have a motion?
Title sufficient, do pass, committee substitute.
Motion is title sufficient, do pass. All in favor, say aye.
Aye.
All opposed? All right, that one goes House Bill 996. Senator Boyd, we do have a basic strike all to this bill, correct?
Yes, we do have, we want to make a proposal. We do have a strike all to this, but this is a piece of legislation. We saw this piece of legislation last year. The legislation is asking basically about what happens when someone has done in vitro when they have done deposited within a bank their sperms and eggs and what happens after that process. And the piece of legislation that was given to us, there was a situation from the representative brought up, and I think Senator Younger's constituent, where that they decided to do, when the husband died and she decided to do in vitro fertilization after his passing. And so the family was not able to get any Social Security benefits because it was after passing. And there are some states that have looked at this particular issue and have said that for those purposes, they could receive government benefits. We talked in committee substantially yesterday. We had a good subcommittee hearing with her, but there's been some concerns additionally kind of raised on that. So what I would propose to do, and council can assist here in doing this, is that what I would suggest that we do is limit this strictly to not regular estate, but just strictly limit this to government benefits, because there's some problems with what happens if they pass away. There's the estate, there's other children. This could be held up for a long time with other children taking care of that and the opening of the estate. So what we would suggest to do is that just for the purpose of government benefits, that they that this would be in effect for.
Is that what the proposed strike all is doing? That's in the packet?
Yes, sir.
Okay, so
You can see it on lines 38 and 39.
all right, you've heard the explanation of the strike all. Any questions? Okay, Senator Branning.
I appreciate the clarification on the restrictive language. I'm not so sure that it actually restricts the language as I think we've discussed before the meeting as we intend, because it talks about for the general purposes of intestate succession. So I just ask, and I'm not going to make an amendment or anything right now, but I should ask it before we get it to the floor, let's look at this one more time to make sure that we are in fact only talking about government benefits. I would fear that this moves along and it does apply generally to intestate succession. I think that could have some really big unintended consequences. Thank you.
Thank you.
Thank you, Senator Branning. All right, any other questions? Have a motion?
Title sufficient, do pass, committee substitute. Strike all.
Strike all. Title, you heard the motion. All in favor, say aye. All opposed, motion carries. Considering we tabled 1318, 1115, our last one.
Okay. On 1115, Mr. Chairman, I would ask that Representative Owens be asked to explain the bill.
I've been a senator twice today.
I was going to say, yes, you may proceed.
Thank you. This bill takes our durable legal custody statute. So right now, youth court in abuse and neglect cases can grant durable legal custody, and that's really a permanent grant of custody. Right now, there's some foreign shopping going on as to whether or not modifications for that grant of DLC are to be filed in youth court or chancery court. This just goes along with current law as far as custody is concerned and keeps that jurisdiction of DLC for modification purposes with the youth court that granted the DLC. And that's an explanation of the bill.
Senator Barrett.
Question, Mr. Chairman.
Yep. I'm sorry, you're recognized.
Yeah, thank you, Representative. Would you be opposed, just to make it crystal clear, if on line 23 through 27, it said after granting durable legal custody of a minor child,
Are you, I'm sorry, Senator, are you referring to the lines on the proposed strike all?
Yes, sir.
Okay.
Where would you like to put it?
On the proposed strike all.
Yeah, that's perfectly fine. That clears it up more.
Yeah, and I'm sorry, what I want to make sure of is if we say the youth court exclusively or shall retain exclusive jurisdiction, because I agree with you, there is a lot of forum shopping, and with the concurrent jurisdiction between youth court and chancery court, there's always a problem in my district. And I think if we said that youth court has exclusive jurisdiction of durable custody, whether it be a modification or the granting of it, are you opposed to that once it gets to the floor?
I'm not opposed to that.
Okay, thank you. Mr. Chairman, if it's okay, I guess I would make that amendment now.
That's what I would, okay. Yes, it is okay to do that.
Okay,
Do
yeah,
that now.
please.
And you,
I would
You wanna
ask
read-
that,
Ethan, will you restate the amendment?
Just the
Or s-
word exclusive on line 25 before jurisdiction, exclusive jurisdiction.
yeah, I just think it would clear things up for chancellors if it says all durable legal custody would be exclusively retained, whether it be a modification or a granting of such. I think it was created pursuant to the Youth Court Act. So I think if we include that term exclusively, people know, hey, I can't go to chancery court. So I think I lost my page, but I think you said it right, Ethan.
Okay. Everybody, any questions on the amendment? You've heard the amendment. All in favor, say aye. All opposed? The amendment carries. For our call, I'll say Representative Owen has done a really admirable job in the House on these areas, working with Senator Boyd, and so appreciate that. Any other questions? We're on the bill as amended. Any questions? I have a motion. Motion is title sufficient, do pass first. All in favor, say aye.
Aye.
All opposed? Motion carries. Now rise and report. The motion is there. All in favor? Aye.